I think we're ready to start. We'll let people come in. I think we're ready to start now. See some more people coming in. Good morning and good afternoon and good evening, everyone. And thank you so much for joining us today to this exciting joint event that Al Tamimi are doing with Ankara. And today we will be discussing a topic that's A, very close to all our hearts, and B, very relevant, even more relevant today, which is joint ventures and how you can set up your joint venture and partnerships for success in the global markets. Next slide, please. Before we start, I'd like to introduce myself and my esteemed panelists today. Many of you know me. My name is Fatoon Hajjar. I am a partner and the head of Al Tamimi's office in Bahrain. Jeff, perhaps you'd like to introduce yourself.
Yeah, thank you, Fatoon. My name is Jeff Walker. I'm a senior managing director at Ankara, joining this morning from Washington, D.C. Great to be here with all of you. Thank you.
Tracy?
Sure. Hi, everyone. My name is Tracy Pyle. I'm a managing director at Ankara in the joint venture and partnership practice. Also happy to be here with you today, also joining from Washington, D.C.
And the Tamimi panelists, Rad.
Thank you, Fatoon. And to mirror Fatoon's sentiments, very sort of pleased to see so many of you here today, and a pleasure really to have a chance to present to you all. My name is Rad El Treki. I'm a partner with Al Tamimi in Bahrain. I head up the corporate structuring practice here, doing a lot in the JV space. And prior to that, I was in Saudi Arabia and in Qatar, and then previously to that in the UK. So again, very active in JVs, and really looking forward to a sort of an active and lively discussion today.
And yeah, thanks Fatoon. Jonathan Reardon, a senior lawyer in the Al Khobar office of Al Tamimi in Saudi Arabia. Like Rad, a lot of my work involves around joint ventures and M&A transactions. I've been in Saudi for about 7 years, and prior to that in Qatar and in China, doing a lot of similar work.
Thank you very much. Thank you all. So very quickly and briefly, most of you know who Al Tamimi is or what type of firm we are. We are the largest law firm in the MENA region. We have 16 offices in 9 countries with a total of 350 plus lawyers. We are a fully integrated law firm, and we have local law licenses to practice in every jurisdiction in which we operate. On to the next slide, please, so that Ankara can introduce themselves.
Yeah, thank you, Fatoon. Quickly, Ankara is a consulting firm based in the United States, so with offices all over the world. Tracy and I represent Ankara's joint venture and partnership practice, which was formerly Water Street Partners, a firm that I started back in 2008 with a couple of partners. All we do is work on joint ventures, and you can see some statistics here. But all we do is work on joint ventures, whether it's launching new joint ventures or working on the transactions, fixing existing joint ventures, or working with companies who have portfolios of partnerships. That's what we do, and very much looking forward to the discussion today. I think we do a lot of work in the Middle East and North Africa, as it is one of the most joint venture and partnership intensive regions in the world. So Tracy and I both have lots of experience serving clients in the region.
Thank you very much. Thank you, Jeff. So before we start, I'd like you all to know that if you have questions, we are doing a Q&A session at the end of our presentation and at the end of the discussions with the panelists. So if you do have any questions, please use the button at the bottom of your screen, and you can just put up any question that you have, and we will get to them at the end of our discussions. Thank you. So we put this quote up here because it resonated with us, and it really says it all. Joint ventures are very complex creatures, and they often, if not usually, involve multiple parties across multiple jurisdictions, all of which are very different in terms of their laws, their cultures, and the way that people do business in those countries. So it's quite a complex creature, and oftentimes, from our experience, stakeholders and parties to joint ventures don't actually understand what the joint venture entails. Now, the complexity of JVs has only been magnified by COVID. If we can go on to the next slide, please. So it becomes more and more relevant as we're coming out of what can only be described as a global apocalypse, which impacted all businesses and sectors, industries, and economies worldwide. And as this chart that's been compiled by Ankura shows, JV and partnership activity continues to rise, especially after economic downturns. And this is true at the moment. You can see in 2021, the activities of JVs has increased. We've all seen it. All the panelists today can tell you firsthand that JV activity has increased, specifically over the last 12 months. The pooling of resources and know-how amongst pharmaceutical companies, academic research institutions, and biotech startups has proven to be pivotal to the rollout of novel and life-saving vaccines. And so joint ventures like that came to the rescue at a time when we needed them most. And these types of joint ventures, often specific segments of know-how, are owned by one or multiple parties, and the complementary tech is owned by another. So the two parties team up to create a JV and develop remarkable products such as the COVID shield. As this trend happens, so does the creation of new sectors. So on an equal footing, for example, technology platforms teamed up over the last 18 months with healthcare and education institutions to create new sector segments such as EdTech and health tech. And in turn, as these new major segments are created, so too regulatory measures become more complex and they tend to intertwine, thereby requiring closer board supervision on operation and compliance matters. And with the absence of on-the-ground supervision by the shareholders, shareholder-appointed directors today are under mounting pressure to ensure the efficiency of reporting lines and implementation of suitable crisis management strategies. So we can see this trend. We can see that as JVs increase, as the world changes, as the market reacts to whatever is going on in that market, so too regulations are developed, so too governance becomes more important, and all the stakeholders to JVs have to really understand their duties in that JV and their obligations. So today, I suppose even more than ever, it's important for these stakeholders to understand exactly what they're getting themselves into and their duties under the joint venture. So with that, I would like to start with the panelists. And I'm going to start with Jeff here. Jeff, what are the common reasons in your view that JVs and partnerships fail?
Thanks, Fatoon. Let me offer two thoughts. One is what we normally hear clients say are the reasons why joint ventures fail. And then two, why we think they actually fail. And they're not always the same. The first is what I think we tend to hear most often from clients in terms of why they fail is that, like, hey, culturally, we're just different. And it doesn't work. We aren't able to kind of work with one another. And I think though culture is important, that for us is an insufficient explanation. And really, from our perspective, an excuse for some bad fundamentals in the joint venture partnership. So there are some very predictable areas where joint ventures tend to fail, or you can think of them as rocks we like to look under when joint ventures have a problem. So one is related to strategy. Are the partners aligned sufficiently and stay aligned across the life cycle of the venture on its strategy? The second relates to the governance. Joint ventures are difficult to govern and suffer from all kinds of kind of poor hygiene, poor governance hygiene, particularly when compared to some of the standards of good corporate governance. You don't see that in joint ventures. A third category of failure is the commercial arrangements between the partners in a joint venture. I think they often do business with themselves as either a supplier or an off-taker, a service provider. And if those aren't set up well at the beginning, that can create issues. And then the last piece is the people. I think it's a really interesting dynamic in a joint venture, particularly when you're creating an incorporated joint venture and injecting people from each of the partners. That's a unique kind of people situation to be into, and introduces some challenges that the partners need to confront. So those are the four kind of categories: one, strategy; two, governance; three, the commercial arrangements; and then lastly, kind of people-related issues.
Yes, that's very interesting, Jeff, and you're quite right. I think the cultural problems often are a very, very important reason for JVs to fail, plus all the other points that you've listed there. Thank you for that. And Raud, what are the legal documents, keeping in mind what Jeff has mentioned, that the parties entering into a JV should actually put in place?
Thanks, Fatoon, and thanks, Jeff. Yeah, I mean, look, the suite of documents that you would typically expect to see in the context of a JV, it will vary from industry to industry. It will vary depending on the sophistication of the parties and the sophistication of the jurisdictions in which they operate, and indeed the nature of the advice they're taking and how early they take the advice. But in general terms, you can sort of categorize the documents into sort of four broad sort of headings or four broad buckets of documents. And it works its way through the life cycle, if you will, of the negotiation. So sort of step one or category one would be sort of pre-discussion documents. Okay, so classically, we're talking about a non-disclosure agreement, an NDA, or a confidentiality agreement. Okay, something put in place before the parties can start to get into the nuts and bolts of what it is that they're going to do. It's typically going to be reciprocal, so both parties are sort of bound by that. It protects against then either party sort of being able to utilize or to sort of exploit the other's confidential information, and it gives that safety to each party. Now, that's particularly acute in jurisdictions where, you know, a confidentiality obligation might not otherwise be implied into that contract. Okay, so with the NDA or the confidentiality agreement in place, the parties are then sort of safe to go, you know, to disclose information, to engage in discussions, to go to the next stage. And that would sort of take us to category two, which is sort of essentially, it's a term summary document. Okay, to use sort of a dry term, but in a more familiar term, a sort of an MOU, a memorandum of understanding, or maybe a letter of intent. You'll often see it referred to in the US, as I'm sure Jeff and Tracy would confirm. Now that's kind of, if you will, the skeleton document that the parties use to kind of encapsulate what has been agreed by them in macro terms. Who will do what the project will look like, what the timelines are likely to be, and so on. Again, they're going to vary sort of industry to industry, but sort of in broad, they're going to cover, as I said, the scope and sort of intended action of the company, who's doing what, when you must do it by. Now, we get asked a lot whether or not that should be a binding document. Typically, it won't be, okay? It's more a statement of intention, but there will be provisions within an MOU or a letter of intent that still need to be binding. Again, confidentiality, for example, exclusivity maybe that only you and I will discuss this, and we won't be discussing it with other third parties maybe, so we're exclusively dealing with each other and so on. Governing law, jurisdiction, these kind of things need to be binding. So we've got the NDA in place, we've had the discussions, we've got the MOU now in place. The next step is to go to a definitive agreement, okay? And that is really the Bible, if you will, for that JVA, the core document. Typically, you'll see it as a joint venture agreement, a JVA, okay? You might see it called a shareholders agreement also. More typically, where a company already exists, it will be a shareholders agreement, but the name of the document isn't sort of conclusive and isn't definitive. And it then really takes the skeleton of the MOU and fleshes that out, okay? Covering the object and scope of the company, capitalization requirements, decision-making, shareholder reserved matters, profit splits and so on, termination, restrictive covenants. It covers the whole ambit there, really. Once that's then in place, and it depends really on the nature of the deal and the nature of the industry, you're likely then as well to see other supplementary agreements that would sit next to the JVA. So for example, if one party is providing IP and technology into the JV, you might see an IP license or a technology transfer license there. If one party is going to be responsible for managing the JV company, you might see a management agreement there setting out, sort of what those management rights are. Is there a rate of remuneration that sort of, attaches to it? You might see secondment agreements again, where one or both parties are seconding staff into the JV company. And you might even see loan instruments, depending on how the capitalization structure is sort of put in place. So those broadly are sort of the main four categories you would typically expect to see in a JV negotiation life cycle.
Right. And would you agree that the better fleshed out these agreements are, and the more details they have, then the better the parties mitigate against the comment that Jeff made earlier, which is, why JVs fail?
Look, I think you're right, Fatoon, and I agree with both you and Jeff on this. I think it goes a long way on this, okay? And to give you an example, look, sort of industry to industry and sector to sector, I know Al Tamimi, we would provide the JV partners with a checklist to work their way through it, okay?
Right.
To try and make sure really that in their negotiations, all the key points have been discussed, and as many of those as possible, as many eventualities as possible are built into obviously the suite of documents.
Right. And Jeff, would you agree with that as well? That the better the parties flesh out these documents and insert all these terms and who's doing what and so on, the more bulletproof the JV is?
Absolutely, Fatoon, and agree with what Rad has said. I think you can predict with a reasonable degree of accuracy where a particular joint venture is likely to get in trouble. And we need to consider that in drafting the legal agreements. I would say, though, that joint ventures, they tend to suffer from not being nimble and kind of dynamic. So there's this balance that needs to be struck of addressing kind of issues that we're likely to confront as partners going forward, but also leaving room, not over-engineering the agreements so that we leave room for the joint venture to evolve. You can't pay for everything.
Yeah, I think that's a really good point. Really good point. Thank you for that. And not over engineering it, but they're just hitting the right spot, so to speak. So Tracy, in your experience, what are the terms in these documents that do hit the right balance? What do you think that parties entering into joint ventures should really pay particular attention to?
Yeah, this is a big and loaded question. I think we could probably speak about this for hours on end. So I will just hit some highlights. And at just an initial point, in a joint venture, you have pretty much all of the terms that you would include in a joint venture or other sort of acquisition agreement if you are buying 100% of a company, like reps and warranties and different rights and valuations. But you also have a whole suite of additional terms that you have to negotiate about how you will open and operate the joint venture going forward. Things like voting rights, who's going to be providing what services to the joint venture, the board composition, just many more different terms that you wouldn't have to negotiate if you were buying 100% of a company. So ultimately, the question here is, what are some of the terms where we see there being the most problems with in a joint venture? And there are many here, actually. I think this is why consulting companies like Ankara and law firms like Altamimi end up working very closely on joint ventures together, because there's just so much in there where you need to have the business plan on the business side matching up with what's in the agreements and coordinating across different groups. So let me just highlight 3 terms that we tend to see some issues with. The first is joint venture scope. And this is really defining exactly what the joint venture can and will be doing, both initially and potentially down the road. We see issues with this because if the scope is too broad, what you can see is that the joint venture ends up competing with the parent companies and sometimes cannibalizing one of the parent companies' other operations or other portfolio companies. Or you can see that the joint venture underperforms and then a parent may or may not have the right to step in and do that business. So for example, we were working with a company in India that had a very broad scope where that was going to be their sole and exclusive vehicle to do business in India. The joint venture severely underperformed. They didn't have exit rights, and therefore they had no way to actually help and develop their business in that market. So scope is certainly one where you have a risk of it being too broad, but on the other end of the spectrum, if the scope is very narrow, you're leaving growth opportunities on the table, and it may not align with the strategy of one or more of the partners. So just being very clear as to what is this joint venture doing and what can it do? What is it making? What can it make in the future? Where can it sell it? What geographies are we in? And you also have to consider antitrust in this as well, since carving up the world geographically or otherwise can have antitrust implications. So scope is one that we see as being important to nail down and align on among the partners, in particular, so you don't have misalignment about what you're thinking about there. A second point is voting and delegations. And this will clearly is very important because it defines your level of control, at least in one way. There's multiple ways to have control over a joint venture, not in the legal sense, but just to exercise influence, like serving on committees or doing audits. But voting is one of the key ways that parties exercise control over their ventures. Obviously, this will depend on the structure of the JV. In a 50-50 JV, really both parties tend to have a vote. So both parties tend to need to approve most items that go to the board or the shareholders. So really the question in a 50-50 JV is what should we delegate to management versus what do we give to the shareholders? In our experience, we typically see that if anything, there's not enough delegation to management. We see a lot of joint ventures where management is handcuffed and unable to run the business on a day-to-day basis because they need to obtain partner approvals. We very, very rarely, I think if ever, see the opposite where the parent companies are very disturbed that the CEO is doing things that they don't need to get authorization from the board. So in a 50-50 JV, it's really thinking about what are those delegations, which could be in the JV agreement or could be in a separate delegations of authority matrix. And also should be revised and looked at over time. We also see that where you have legacy agreements that haven't actually been updated. In a majority minority joint venture, more of the voting question is also what are you delegating? But beyond that, it's really what does the minority partner or partners have the right to vote on? Ankara, we've done benchmarking of joint venture agreements that are typically large strategic joint ventures among partners that are really operating in multiple spaces and coming together to do things that they couldn't otherwise do on their own. And what we found that was very interesting is that the voting rights of the minority partner were not correlated with the percent interest that the minority had. So a 30% owner didn't per se have fewer rights than a 49% owner, which we found very interesting. And what this suggests is it's really all about negotiation and negotiating power, as opposed to what your ownership interest is and what market is for, say, a 20% interest owner. The most common, unsurprisingly, the most common rights that people had as minority partners were 2 large things like amending the agreements, issuing new shares, terminating the joint venture, selling the JV's assets, et cetera. But then actually a good number of minority partners also had rights to do things like approve the annual budget, approve material investments, appoint the CEO or approve the CEO's appointment, approve material acquisition. So there was a really wide range in those rights, but thinking about what is the right level and how do we want to run this joint venture going forward. And one thing I will note is just because you don't have a right to vote doesn't mean you can't otherwise exercise influence through things like serving on committees, having secundees in the joint venture, auditing the JV, et cetera. I've been talking for a while, so I will just briefly mention
no, that's very, very interesting. Thank you so much for that insight. And I agree with you entirely that the minority rights are really important for the partners to negotiate from the outset. And this miscorrelation that you've seen at Ankara between the percentage held in a JV and the rights of that party, that's very, very interesting. And we actually also, from our perspective, advise a lot of minority shareholders before they sign the dotted line, before they agree, to make sure that they've got the powers, all the powers that are given to them, A, under the law, and B, that they can negotiate with their partners. It's very, very important. And thank you for that interesting comment. So let's turn to Rad. Rad, I just, do you have any comments on what Tracy has mentioned just now before we ask you about the enforceability of JVs?
No, I think I agree with you too, and that it's a very good summary there. And I entirely agree with Tracy that really a lot of it comes down to, relative leverage and relative bargaining powers. Okay, it's very, very unlikely that on any given JV, there's going to be total equality. Okay, depending on the nature of it, someone's going to have a stronger bargaining position and stronger leverage, and that will ultimately be reflected in their negotiations and what's then agreed in the ultimate sort of final document. So I think that's very, very relevant.
And in terms of enforceability, can parties make sure that their JV agreements are bulletproof?
It's the magic question, this one, Fatoon. So look, we always say there's no point having a sort of all singing, all dancing JVA agreement if ultimately, if it comes to a sort of a dispute situation, you can't enforce it. Look, the general position in GCC states is that, parties have contractual freedom to agree whatever contractual terms they want, provided that those terms are not contrary to mandatory provisions of law or to public policy. So in theory, there is quite a wide sort of remit of freedom there for the parties to agree. I noticed as well, Amr Khalid, you raised a question about the sort of, a conflict between a JVA and an AOA, and it's a very, very, very relevant question. So in the context of sort of making something binding, okay, we would always advise a client insofar as possible to try and get all the key terms from a JVA into the constitutional documents of the company, whether it's sort of an articles of association or a memorandum of association. Okay, ultimately the AOA or the MOA, it's a notarized document. It's considered to be a document of public record. Okay, so you're always going to improve your chances of enforceability. Okay, if your provisions, maybe a call option, a put option, there's certain transfer rights and so on, are enshrined in the MOA and the AOA. Okay, where there's a conflict between those two, okay, so where an MOA or a sort of an articles are silent on a point and there's something in a JV agreement, again, look, provided that it's not contrary to mandatory provisions or public policy, typically the starting position, the starting assumption would be that those provisions would be binding. Where there's a direct conflict, however, between a provision in a JVA, okay, and a provision in the articles or the memorandum, again, on that scenario, the starting point would be that the articles or the memorandum typically would take precedence over the JVA, okay? But I've been talking about whether or not something's binding or whether or not something's enforceable, okay, which is sort of one side of the coin. The other side of the coin then is a more practical consideration, okay? Even if a provision is quote unquote binding, it's not contrary to mandatory provisions of law. You have to sort of, take one step forward and think about the issue of remedies. Okay. So, in a contractual situation where one JV partner hasn't paid another JV partner that which they're required to pay, and you went and litigated on it, the measure, the remedy would typically be damages and, compensation. And compensation would be adequate there in theory. Okay. I wasn't paid a sum, or the company didn't pay me my management fee. I litigate, I get paid that sum. Okay. In other scenarios where, a JV partner hasn't done what he's required to do, he hasn't taken steps that he's required to do. For example, there's a transfer provision there, there's a call option. I exercise that. I require my JV partner now to sell me his shares, and he simply refuses. So I'm not going, I'm not going to abide by the provisions of the JVA. Okay. In theory, such a provision, if it's well drafted, is binding and is enforceable. The catch is, if you were to take that document to the, to the courts of most GCC states, the remedy you'd be likely to get would be damages. Okay. Whereas in a UK court, for example, you would seek specific performance, i.e. an order from the court compelling the counterparty to transfer those shares. Okay. Which is ultimately what you would want. Okay. Damages may not be sort of a suitable remedy for you. So, all of these things have to be taken into account, in negotiating your JV, negotiating governing law provisions, negotiating jurisdiction provisions, and even deciding sort of, ultimately where the holdco maybe for your JV might be situated. Okay. You might take the choice, and it's something we often recommend to clients, in these kind of scenarios, despite the fact that the operational companies, the opcos, might be located in Saudi, Bahrain, UAE, and so on, you might ultimately have at the top a holdco, okay, which then owns the opcos, and that holdco is established in a jurisdiction where A, the kind of provisions we're talking about are enforceable, and B, the remedy that you would seek in a breach situation would be adequate and suitable for you in the circumstances.
That's very interesting. Very interesting. Thank you, Rod. That's a good way of avoiding the issues that we face, we often face in the GCC. So on to the next slide. Jeff, this is for you now. We've heard here about parties going off and litigating and suing. Now, obviously, in my view, and from my experience, one issue here is that as soon as there is an issue that warrants one party to go and litigate and claim damages and so on, pretty much the JV has started to deteriorate and will probably continue to do so, because the relationship of the parties has been put on the line, let alone everything else in terms of the commercial agreement between the parties. So in your experience, when governing joint ventures, what are some of the biggest mistakes that the partners make?
Yeah, I think, and again, I'll try and be a little bit provocative here. The governance in joint ventures tends to be quite bad when compared to what you would expect to see in a corporate board. And part of that is structural, and I think part of that is behavioral. The structural challenge is that a director on a joint venture board is wearing two hats. They're wearing the hat representing the joint venture, and they're also wearing the hat representing their shareholder, and it's their responsibility to kind of navigate how to do that in a way that's consistent with their duty as a director. But like structurally, that's difficult. I think it's also structurally difficult because the directors on a joint venture tend to be the people who own the P&L of that joint venture, whereas like a Warren Buffett on a corporate board, right there, it's just a different dynamic. There's a much more intimacy with the business. So that can lead to a lot of the behavioral problems that we see related to governance. And I think, so an example of something that partners tend to get wrong is they are misaligned on the posture they want to take as a board. So if partner A And by the way, in a joint venture, you can take a decision whether you want to be deeply involved, what we would refer to as a board of managers, into the operations of the business, which is sometimes makes sense, into like managing it very closely, or more like a corporate board, which can also be appropriate depending on the circumstances. So the board has a choice about kind of the posture it wants to take. And I think too often one of the things that we see is like each director has its own idea, his or her own idea about the posture to take, and that creates all kinds of governance issues because Director A is deeply involved. Director B, it's hard to get him to show up. Director C asks for tons of information. Director D does not, and the result is that the joint venture kind of suffers from that. So I think one of the biggest governance issues that we see is a board that is not fundamentally aligned on the role that it wants to play in governing that joint venture. And if it's not, then all kinds of bad things happen. Other types of challenges, governance-related challenges that we see, joint venture agreements tend to define things like the voting rights, the size of the board, maybe how frequently it meets, but that's a long way from describing what a functional board looks like. So things like the expectations of a director, which committees exist, often created in the legal agreements, but the charters of those committees, what their authorities, if any, they have. So there's a lot of work that kind of remains to be done as it relates to governance after the legal agreements are signed. And it gets into like, well, how are we actually going to work together as partners in governing this joint venture? And to the extent we're not aligned on that or don't do that work, that creates all kinds of bad behaviors. And maybe just to share, a story to bring this to life a bit, because it can get quite bad, is an example of a joint venture board that we worked on, where one of the directors from a partner announced that he would be leaving the board after this session, and the other partners directors got up and cheered his departure. So that's an extreme example. I hope none of you are confronting that, but it can get quite challenging.
Yes, I think you're right. Absolutely, really important, because we also have seen deterioration at the board level, and the charters are very important. The alignment of the board members is very important, and the charters, the governance charters for the partners are very important, and for the board. And I think, what about the continuous sort of, you've got to refresh, you've got to make sure the board, you've got to train your board members. Don't you agree, Jeff? You've got to make sure that they know what's in those charters and that they apply them. Because more often what happens is that board members come, they're elected to the board, they sign the multiple charters that they have, and that's it. They never look at them again.
Right. Yeah, I think that the training we found, the training for corporate directors has become quite good over the years, and there's all kinds of resources out there. In the Middle East, for instance, there's an organization called the GCC Board Directors Institute that some of you may be familiar with. Right. I think in our experience, like, companies tend not to train their joint venture directors with the same kind of intensity and thoughtfulness, really, that they do their corporate board members. So that's mistake one, is we don't train our directors to sit on the boards of our joint ventures. Mistake number two is we train them, but we train them in the wrong way. We train them to behave like corporate directors on a joint venture board, which is near the right answer, but it's not the right answer, because there's some important difference between joint venture boards and corporate boards.
Thank you. That's very interesting, actually, and I don't think we think enough of that distinction at all. And on the same vein, so the board is one thing. What about the actual partners, the shareholders? How active should they be in governing the joint venture, in your view?
My answer to this one, Fatun, will be like maybe a little bit unsatisfying, because it depends. It depends. Yeah. I think what I think partners need to be very deliberate about doing is deciding the role that they want to play in governing the joint venture, and aligning the organization on, this is the posture that we have chosen, and here are the implications of that posture. And it means we're going to do the following things, we're not going to do these things. And I think what we too often see is that it's kind of, we haven't decided how we want to govern a joint venture as an organization. So individuals govern it in the way they think it should be done, which leads to a very confusing situation, and frankly, a maddening one for the joint venture management team, who is getting different signals from every one of their not just partners, but every one of their directors on a board. So I think what we advise, I think there are, we think about it kind of on two dimensions. If I'm a company and I have a joint venture, I think about the governance in two dimensions. One is the joint governance. So that would include things like, do we have the right people on the board? Does it meet with the right frequency? Are its charters clear? Are the meetings effective, et cetera? So those are the things that we do jointly with our partners. But then there's a different category of what we call kind of shareholder governance. And it's like, are we clear internally on who the accountable executive is for this partnership? Are our directors trained properly? Are they resourced in the right way? So those are totally in our control. And I think shame on us if we don't get that right. But as part of that, we should take a decision about how active we want to be as a partner in governing this joint venture.
Thank you very much. Thank you. Yeah, I know that was a tough one, but and thank you for that. And Tracy, any comments on what in your view a best practice joint venture board may look like?
Yeah, so I'll keep this one short and sweet. Basically, a best practice joint venture board has directors with a mix of skill sets. And that's something that we often don't see because everyone's just thinking about who do I want to put on the board, and sometimes not thinking about, as a whole, what skills are needed on this board. So you may end up with 5 finance people, but 0 folks with operations experience or no technical background. So you really want to have overall a group of people with a wide variety of skills that can then reach out and understand what's happening in their area of expertise in the joint venture. You want folks of the right seniority, and by that you mean folks with the right amount of time that they can dedicate to the joint venture to really be able to make informed decisions and be involved and understand what's happening in the committees. But also, so they have the time dedication to do that, but also the seniority to actually make decisions at the level so that they don't have to go back to the parent company for every little decision. Sometimes obviously there will need to be discussions in the parent company. So it's a mix between skills, seniority, ability to dedicate time. Typically in terms of size, we recommend more around 6 to 10 joint venture directors to get that skill set and to have a critical mass of directors who can serve on committees. We find it's a best practice if a board member actually serves on each committee to make sure there's correct linkage between those bodies. And then beyond that, you have to have all of the things that Joff mentioned, like the charter, the ways of working, to make sure there's clean governance, good communication beyond just who is in the composition of the board.
Thank you, Tracy. That's interesting. Jonathan, we haven't heard from you yet. How are you? You're still here? Yes, there you are.
I'm still here. I'm still
good,
here.
Good,
yeah.
Good. So what happens when the board doesn't agree, Jonathan? And what are some of the deadlock resolution mechanisms in JVs for such a situation?
Yeah, thanks, Fatun. So, in a well-drafted JV agreement, there will be typically a deadlock resolution clause included in there. What the rights mechanism is going to be ultimately, if the parties can't agree, is going to depend to an extent on the nature of the parties in the JV and the nature of that JV. If you have a JV which is not viable unless both those parties are involved in it going forward, then some of the provisions that you might include, allowing one party to buy out the other, may not necessarily be suitable for it. I mean, typically, the initial stage in the mechanism will be a process allowing the parties to negotiate and to try and agree a way forward in relation to the matter where they have got the deadlock. And that will typically involve escalation up to increasingly higher levels of senior management, going up to the CEOs or chairpersons of the JV parties. Sometimes there's something included whereby matters may be referred to one or more independent directors who may be on the board, for them to assist in that negotiation process. And sometimes, and we've seen this in a number of JV agreements recently, and it does depend upon the nature of the matter, which is the subject of the deadlock, but referral to some form of independent mediation process. So we have seen provisions included for example, matters to be referred to mediation in the DIFC under the LCI mediation rules. But that's probably not going to be suitable for a lot of commercial matters. If you've gone through that process, and there'll be normally a defined period for it, and matters still aren't resolved, then there tend to be three alternative approaches. One is that the status quo is just maintained, and the JV continues, and you may have some provisions in there that, for example, if the parties haven't been able to agree the business plan for the next year, or they haven't been able to agree the budget, that there may be provisions included whereby you revert back to the previous year's business plan or budget, subject to whatever the parties have been able to agree. And that's an approach, as I say, where maybe one party doesn't, the parties don't feel that they want to buy out the other party. Another approach is to have a mechanism in the agreements allowing for the compulsory sale or purchase of a party's shares, and there are a number of mechanisms around that, from, in some cases, relatively simple put and call option agreements being included, or more complex provisions, so-called Russian roulette, or sort of Texas shootout type provisions, which are variations on sort of options where one party can give notice to the other party, requiring them either to sell or buy shares at a specified price, and the other shareholder can either accept it or reject it. If they reject it, then it kind of gets reversed. The advantage of that type of mechanism is that it probably should guarantee that the parties are talking about a realistic price. But it's that's not going to be suitable for all cases, and certainly not if some parties got a kind of unique role in relation to the joint venture. And I guess the third mechanism that you would see is that the parties may decide, if they have fundamental disagreements and nobody wants to buy out the other, that there would be a winding up of the of the joint venture entity.
And that
Um,
would be quite extreme, right, Jonathan? That's the nuclear
yeah,
option. I mean,
yeah, that's the kind of
Yeah.
sort of nuclear option.
Yes.
Tends to be if the JV's not viable,
Yeah.
unless both parties can continue in it.
Yeah.
It might be chosen if there are, for example, specific maybe IP technology assets which have
Yeah.
been contributed by a party, and they wouldn't want the JV to continue with those in there. They would want to extract those. So that might be, a nuclear option.
Thank you, Jonathan. I'm going to have to move on now because I'm being told that we're short of time.
Sure.
So that's very interesting and very complex, very, very complex topic, actually, and something that JV partners need to think about very, very seriously and clearly before signing anything and before entering into the joint venture. So talking about exiting a JV, hopefully rather than the nuclear option we just mentioned now. Jeff, if you could move on to the next slide, Joe, please. Jeff, so JV exit generally is a complex topic. How can we simplify it? And how can deal makers simplify it in their own heads?
Yeah, I'll maybe offer a few thoughts related to exit and keep it brief here. I think one is it's almost always the case in a joint venture that there's a natural buyer and natural seller. So let's have that in mind when we're structuring the deal and tailor it appropriately. Two is if you can create an option for a third party sale or an IPO, that tends to drive better behaviors. And then I think a third is consider some form of lockup period where it's like a commitment to figure it out with one another in good faith before we're even going to like consider exit options. So there are some good practices that we think when considering exit, which you need to when you're doing the deal. There's also a kind of a creative set of exit triggers. We have an article that we've written on this topic, but in the interest of time, I'd be happy to share it with you and your colleagues, and we can share it with the participants out there.
We can share it. That would be very, very interesting. And I think you're right. I think let's try and make it work is the bottom line as much as possible before we go in. Thank you. And Rod, call and put options. I mean, we see them all the time. How useful are they?
We do see them all the time. You're right, Fatoon. And I think, looking at them in isolation, they're not massively useful, okay? But I think coming back to what both Jonathan said and to what Jeff said, okay? I think call options, put options, drag along rights, tag along rights, they all have to be built into sort of a wider matrix, a wider structure, okay? Bearing in mind sort of, the broader consensus on exit and termination. Okay.
Right.
As Jeff rightfully said, there's typically sort of one party would be the buyer, one party would be the seller, and it's always kind of tacitly understood between the parties, right? So that should be factored in, okay? And I completely agree with Jeff as well that sort of, look, a potential IPO or a potential divestiture of the whole company, okay? Call and put and drag and tag and all that good stuff should be built into those kind of considerations. And 100% I agree that that's more likely to sort of galvanize the parties' minds and motivate the parties to work together amicably, okay? If potentially sort of in a deadlock type situation, there is an option and there is an impetus, okay, to potentially divest of the whole company to a third party. So call and put options, buying of themselves are call and put options, but as part of that wider structure, that wider sort of exit and termination consideration, they're useful, very useful, yeah.
And sorry, very quickly, Jonathan, do you have anything to add to what Jeff and Rod have said on this?
Yeah, I mean, just very quickly, just in relation to drag and tag. The drag is an important right for a JV where you've got a kind of majority shareholder.
Right.
Less suitable when you've got two shareholders who've got similar size shareholdings, but if you've got, maybe if you've got a 75% shareholder and a 25% shareholder, it's important because it gives that majority shareholder the ability to kind of exit and force the minority shareholder to sell. And the flip side is the tag along is an important, minority protection for that 25% shareholder, because it means they can get out at the same time as the majority shareholder. So,
Right.
they're important protections to have in there.
Yeah, thank you for that, Jonathan. And finally, Tracy, last but not least, should JV agreements include lockup periods, and what is the relevance of restrictive covenants upon exit?
So in terms of lockup periods, as Joff mentioned, this can be a great way for companies to say, we're in this together, we're going to stick this out and get this off the ground. Lockup periods tend to be seen in JVs that are more startups where capabilities are coming together, as opposed to, say, a partner buying 50% of an existing business.
Right.
Tend to see them if there's heavy reliance on one or more partners, like you need someone's IP and you need someone else's land license. So we tend to see them more. According to our benchmarking, about 18% of JVs have a lockup period. So it's not in every joint venture, but there are certainly situations where it can be very, very useful.
Right.
In that sense.
And restrictive covenants, how useful are they?
So restrictive covenants on exit, this can vary. I'm not totally sure actually what you're asking in this question here.
So, we exit, but there's something in the JV agreement.
Oh, yes. Okay,
from
thank you.
Joining a similar business. It's okay.
Yes. So we actually often see restrictive covenants that after exit, you have to take a few years before you can compete with the joint venture.
Yeah.
Can certainly incentivize companies to work it out. The question is enforceability of those covenants. Sometimes they are enforceable, sometimes they are not. Sometimes there are other post-closing obligations, like if a joint venture is using one partner's technology, that partner exits, the JV may have a right to use that technology for a period of time after that partner's exit to be able to transfer to a new technology. There also tend to be sometimes transition services agreements. So you can have restrictive covenants in terms of competition, but there are also often other post-closing obligations related to intellectual property, related to services, related to people, and the like.
Thank you very much. Now, I'm very conscious of time. I think we're going over, but we do have a question. Do we have more than one? We do have, we have one from Khaled Hisham about the requirements that need to be fulfilled by a local JV regarding antitrust regulations of jurisdictions other than that of the country in which the JV is or will be operating. So what are the requirements that a local JV has to fulfill regarding antitrust regulations in a country in which the JV is other than a country that the JV will be operating, so other countries? Who would like to address this question?
I'd be happy to take that one, Fatoon. Thank you. And hi, Khaled, and it's a good question. Look, on a case-by-case basis, there are antitrust laws that have extraterritorial reach, okay? The classic examples are the US antitrust legislation and regime, and also the EU antitrust sort of legislation and regime. Now, sort of despite the fact that the OPCO may be based in Bahrain, maybe based in Saudi, and on the face of it have nothing to do with sort of EU jurisdictions and or US jurisdictions, both of those sort of bodies of legislation, and in particular the US scheme there, is quite aggressive, okay? Quite aggressive in its ability sort of for its tentacles to reach out and apply to other jurisdictions. Now, the kind of circumstances where that may happen, it would depend on the nature of the parties going into the JV, whether or not one of those parties has operations in the EU or in the US, has a group company in the EU or sort of in the US, is HQ out of those jurisdictions, maybe is even trading with those jurisdictions as part and parcel of what's going to be done, with respect to the JV. So I suppose the key advice is, on a case-by-case basis, always seek suitable advice, antitrust advice, early on in the transaction, okay, to be able to ascertain exactly which regimes do we have to comply with and what do we have to do in order to comply with those regimes.
Thank you very much, Rad. Thank you. And another question we have from Rakan Kadasa, which is, when is it better to suggest entering into a consortium rather than a JV? So when is a consortium more appropriate to a joint venture? Interesting question. Who would like to?
Yeah, it is an interesting one. And Rakan, I'll
Yeah,
take a cut at
please.
it, but I'm not sure I have the complete answer. I'm going to think more
Right.
about it afterwards. You know, a couple of considerations. One, I think the number of partners. You know, consortia tend to have high volume. So when you're thinking like more than 4 or 5, it's a form. I think also the nature of the business is, and maybe I'm stating the obvious, but I think of some examples of consortia. For instance, there was one here in the States called Sematech, which was a consortia of technology companies who were pulling bits and pieces of R&D to facilitate advances in microchip technology. There's another consortia also like in Canada called the Canadian Oil Sands Innovation Alliance or something like that. But it's a bunch of oil producers say, hey, we have a shared issue related to like environment and emissions. Like, can we help one another? So we're going to contribute technology and look for combinations across us, but we all have our own business because this is a shared challenge that we'd all benefit from solving. So I'm sure there are additional considerations, but one is, you know, consortia, they tend to have a high volume of partners. Two is the nature of the business means there's some like shared benefit that is important to everyone, but difficult for anyone to kind of solve on their own, or maybe it makes sense to tackle together. So that's my
That's very clear.
top of head answer.
Thank you very much for that. Do we have any more questions, Joe? Do we have? I don't see any more.
We do in the chat. Sorry, Fatoon. We have one from Amr Khalid. Is it recommended to have a 50-50 board, and does this support the JV management? Tracy?
Sure, I can take that one.
All right.
Do see a lot of boards that are 50-50 where they have the same number of representatives from, say, each of 2 partners. It's quite common, and it can be very effective because it promotes collaboration, because you really have to come together as partners and make a joint decision to inform management. At the same time, it can also handicap management because they can go to the board and not get a clear answer while the parents, you know, fight it out. So I think that's where the delegations to management come into play, that those should be set at a level where the day-to-day, the business can operate on its own and only really big questions come to the board and can result in that deadlock. But it can be very effective. That being said, sometimes it is helpful to have an independent board member or a respected expert that may not be a voting board member, but can be in the room as a voice to kind of help break some of those ties, particularly on more technical or operational issues.
Thank you, Tracy, for that. Very clear. Are there any other questions? I can't see them, so maybe Rad, if you can see them.
Yes, no, fine. There's one more as well from Khalid Hashim. What is your experience with the Saudi Center for Arbitration? Perhaps one for you, Jonathan.
Jonathan.
Yeah, so thanks, Khalid. We are seeing more JV and other commercial agreements which are referring to arbitration to the Saudi Center for arbitration. I personally haven't got experience of an arbitration process going through them, but I know that the colleagues on our sort of litigation team are kind of working on 1 or 2 of those arbitrations, and I mean they actually speak reasonably well of the process with the Saudi Center for Arbitration. So it's certainly something that's kind of sort of developing and getting more used in Saudi. Although I've got to say that we're still seeing a lot of joint venture agreements where there is referral to arbitration in foreign jurisdictions.
Right, right. So it still needs time. It hasn't quite.
It still needs time. Yeah, that's right.
It needs time, and let's see once the big decisions come out, whether or not. I think we'd probably say to try other more well-known and tested jurisdictions for arbitration than Saudi at present. Would you agree with that?
Yeah, it depends. It probably depends who the parties are, but sort of we certainly find that international parties tend to prefer to go to, I don't know, DIFC or Singapore or somewhere like that.
Yeah. Thank you very much. Do we have any more questions? I don't think we do. Well, with that, I'd like to thank you all for joining us today. We really enjoyed the discussion, and I hope you did. We have the slides if anyone is interested, but more importantly, you've got the contact details. We will be reaching out to all the attendees today, and you are most welcome to reach out to either Al Tamimi or Ankara or both for any further discussions. I'd like Jeff to say a word before we close off. Thank you so much, everybody. It was a pleasure to see you all here today.
Yeah, thank you, Fatoon, and thank you all for joining us today. Really appreciate the opportunity to join Tamimi. And just, I know it's we kind of hit the wave tops here, so happy to continue the conversation with any of you if it's helpful. So we'll share our contact details afterwards, and would welcome the opportunity to continue the conversation.
Thank you very much, Jeff. Thank you very much, everyone. Thank you and goodbye.
Thank you, guys. Thank you.
Yeah, thanks, everyone. Thank you.
All the best. Take care. Bye-bye.
Thanks, everyone. Bye.
Thank you.